So, yes, good afternoon, everyone in Helsinki, and good evening if you're joining from my end of the world down in Australia. Um, my name is Jess, and it's my great pleasure to be with you all today virtually to share some insight into my PhD work to date. The title of which was just read out, a bit of a mouthful, and we'll see how that goes towards the end of my PhD. But basically, what I'll be presenting today is an overview of my thesis, provide like a holistic summary of where I'm at with my work. Hopefully, to get some feedback from the audience, if you have any during the Q&A, would be great. And I'll delve a little bit more into the conceptual framework as opposed to the heavy WTO side of things, just based on the audience. But if you want to go there, let's go there. There'll be time for that towards the end. So with slides, could I just check where we're up to with that? There I am. Hello. Okay, there he is. Awesome. So that was slide one. So let's pop to slide two, if that's possible. Thank you so much, Marcia, for helping with the slides today. So, okay, today, as you can see, the roadmap will be covering my thesis question, the conceptual framework I'm using, a summary and analysis of some literature, including the wonderful Visa Kirky, who I had the pleasure to spend some time with in Helsinki recently to work on my thesis. Thank you, Visa. And we'll discuss a little bit more about how I integrate some of Visa's ideas. And then we'll move to the relevance and importance of the study, according to me, and then my thesis work to date. Fantastic. So without further ado, let's jump on into those topics. First with thesis question. So yes, slide, please. Amazing. So my thesis investigates how states can implement trade restrictive measures which legitimately restrict the trade of farmed non-human animals within the WTO regime and contribute to challenging the conceptualization of these lives in traditional property terms. That's the very formal formulation of my thesis question. But it's basically looking at how we can legally stop live export in a broad sense, but also the ramifications of this more broadly for non-human animals who are traditionally deemed to be property by the law. So my thesis investigates this question by using a novel application of critical animal studies, or CAS, that as a lens to a subject in the field of global animal law, or GAL. And then if we could slide, please. Cool. So the objectives of doing this. First, to demonstrate the recognition of non-human animals in more than commodity terms, and this is applied and developed from Visa Kirky's commodity more than commodity regime work within the WTO regime. Secondly, to analyze the leading animal dispute settlement body cases of the WTO, which relate to non-human animals. And then third, to draft a proposed model of how states may defend highly restrictive trade measures. So in my case, a trading ban against live export, if challenged by another state. And that case study goes into quite like a technical legal case that I go through step by step. So I propose that the process of restricting the trade of farmed animals challenges their traditional property status, as would align with their common position in the commodity regime under Kirky's framework. A critical component of this research question is whether it's possible to interpret animals in the DSB decisions in more than commodity terms, and I will define and position this term more in part 3 of my presentation. For now, suffice to say, it's the recognition of animals in these terms, more than commodity terms, that's critical for us to even discuss and recognize these beings as having their own moral status. Thank you, Rich, in the audience, for his help with my work on this term. So without the recognition of some elements, such as sentience or capacity to suffer, or a similar element is often referred to in animal law literature, we limit our legal ability to separate animals from conventional property status in the law. And I consider the animals discussed in my thesis, mainly farmed animals such as cattle, to have moral status. Okie dokie. So, responding to the DSB's recognition of non-human animals in more than commodity terms would support states, I argue, which seek to restrict trade of farmed animals. I ultimately argue that greater recognition of animals in these terms by the DSB, by states, by individuals, will allow and encourage states to accept the possibility of creating new laws which recognize their moral status and consequently protect their interests to a great extent. For example, by implementing a live export ban. And the significance of this argument may be extended beyond the WTO regime context to provide further insights on the topic of animals, generally speaking, in regional trade and investment agreements, as well as in domestic regimes. So let's now move to the second topic of my presentation, my conceptual framework. And we'll do a slide now, please. Amazing. Thank you so much. So I take an approach which applies CAS, critical animal studies, lens to a field in global animal law. The guiding principles of CAS can be understood broadly as first, liberation from systems of oppression and domination, and second, a critical analysis of those systems to ground strategies for liberation. And my thesis is broadly guided by both of those principles. Global animal law is a field that's technically more nascent than CAS, though the subject of protecting animals in global legal spaces precedes this term. But Anne Peters has identified a few general features of the field that she defines, including that, quote, it could stimulate law reform by identifying legal gaps, end quote, and that it should, quote, serve as a, quote, branch of international law and as a scholarly discipline, end quote. I employ GAL as a field that promotes law reform strategy that advances the interests of animals who are, for instance, internationally traded, a topic which both functions at the international level, but likewise demonstrates the widespread international dimensions of issues facing animals in the modern world. Okay, so in sum, I use CAS, which is a critically analytical tool motivated to identify strategies of liberation within the field of GAL. And while identifying GAL may be sufficient to analyze the topics of animals in international law, the CAS lens, I feel, offers a more active on-the-ground focus and direction for the analyses. So applying that to GAL is good for, I think, balancing the weaknesses which have been identified with both approaches. Broadly, the GAL may suffer from siloing in Western academic institutions and general exclusivity, and CAS may suffer from emphasizing strategies that achieve unsustainable change. So I hope the two balance each other in a good way. So applying the active focus of GAL to the international focus of CAS to the international focus of GAL, and then we'll do a slide click. Very nice. Maybe we go, yeah, that's the one. So I aim to describe and critique the problem of the status quo treatment of animals as tradable property within one legal space, international legal space, the WTO regime, to ground a practical strategy to restrict harmful behavior, live export, which has proceeded from this status quo treatment. Cool. So how does this topic fit within the literature? Let's look at that now, and we'll do a slide change, please. Awesome. Okay, so the first objective of my thesis, as mentioned before, is to demonstrate the recognition of animals in more than commodity terms within the WTO regime. And this would involve, first, a recognition of animals in those terms in DSB decisions specifically. Second, it would support restricting animal trade. And third, it would involve applying Kirky's more than commodity regime. And then I distinguish this from two kind of similar works in the animal law space, so Faber's living property and Fernandez's quasi-property, and why I ultimately lean towards Kirky's as a descriptive tool for my thesis. So let's do a slide change to look more at, amazing, what the more than commodity regime is as defined by Quirky, and this wonderful big old quote that I wanted to put in so that we have a good, adequate representation of the regime. So as you can see, it's divided into three main parts. We've got irreplaceable and familial property, animal protection, animal conservation. And let's, I think we should work through this quote because it'll be pertinent to the points I make. Irreplaceable and familial property refers to the emerging status of some animals within private law. Animal protection means the limitation of animal status as things and the extent of property rights over them. Animal protection law protects animals as intrinsically valuable individuals. And questions on that term that I'd love to talk about more, and is often based on an implicit or explicit recognition of animals as sentient beings that can suffer, whereas animal conservation involves the protection of animals for other reasons, such as the protection of some animals because they're members of an endangered species. Okay, so that is how Kirky defines the more than commodity regime. I apply the term in my thesis as a descriptive tool, especially in my analyses of the three leading DSB non-human animal cases. So the use of the term to me indicates an identification of animals in a way that predominantly aligns with the latter two parts of this more than commodity regime, that animal protection and animal conservation. So firstly, in a way that challenges their animal status as things and or recognizes their capacity for suffering or sentience. So this would relate to animal protection laws, which often recognize these features. And in my context, extends to any legal recognition of their more than commodity elements, such as when the DSB describes animals in these terms. And second, in a way that recognizes the need to be protected in perhaps wider community terms. And that would relate to animal conservation laws, the third part of Kirky's framework there. But I extend to any legal recognition of their more than commodity elements, but this would be through the more communal channel. Again, as recognized in my context in DSB framing of non-human animals. So it's predominantly the first challenging animal status as things that aligns most with my approach. So my doctrinal analyses that I conduct in chapters 5, 6, and 7 right now, we'll see if they're the numbers that stick in the end, ask whether there's a first more than commodity conceptualization of animals in the WTO regime as represented through the DSB. And B, the possibilities this presents for states in relation to protection of animals from harms. And my analyses conducted in the process of answering this question must be read with the following understanding that I go into in great depth in current chapter 4, which is the historical conceptualization of animals in the WTO, which persistently frames these lives in terms which more align with the commodity regime as kinds of commodities whose health is important as an indication of the viability of the product being the animal, or a means to provide others' ends, usually financial ends of humans. So in my thesis, I argue that this narrow interpretation of animals, historically speaking, is not only insufficient, but inconsistent with increasing recognition of the more than commodity elements of animals by certain WTO bodies, such as the DSB. Cool. Let's move to the next slide, please. Thank you so much. Let's understand perhaps a little bit more about where this awesome new framework of 2024 and beyond fits within other similar work happening in the field. So that's Favors, Living Property, Fernandez's quasi property, also awesome work. But how do all these terms kind of relate to each other? In short, both Favor and Fernandez's work explores, well, how modern animal welfare and protection laws typically clash with traditional property ownership incidents, but It's Kirky's regimes that I feel offers a particularly useful descriptive account of the conceptual legal landscape of non-human animals in at least modern Western legal systems. All three highlight tensions between the legal characterization of animals as property and then the legal protection of animals, which seems to challenge their property status. Um, but it's Kirky's regimes that offer an appropriate opportunity in my thesis of applying a descriptive tool to critically identify characterizations of animals in not strictly commodity terms in an otherwise strictly commodity space, which would be the WTO regime. So, to delve into this a little bit more, and we'll get into the nitty gritty a bit because I think this hasn't fully been explored, but I'm excited to explore it. So, Favor has previously defined his concept of living property as referring to vertebrate animals who are property and shall be identified by either specific name or group reference. He outlines the scope of the rules of living property as first, the rights of owners will have to be limited to some degree to accommodate some of the interests that their property asserts against them. Fascinating. Second, humans who are not animal owners will have new duties towards living property, who will hold certain rights towards living property that they do not have towards non-living property. And third, living property will hold certain rights themselves. So living property will hold certain rights themselves, which is quite a unique, I think, distinction of the living property concept. So in introducing this idea, Favor states, quote, the premise of the article in which he introduces the term is that it is ethically acceptable to continue to have animals within the property status. Okay. Kirky's more than commodity regime could be read to include a recognition of the dual property, non-property features as recognized in Favor's account. Kirky's regimes, for instance, also acknowledge that animals have a present property status, can have protections that relate directly to their interests. However, unlike living property, which suggests a sort of hybrid status that's still anchored in ownership, Kirky's regime acknowledges that animals, quote, legal status cannot be exhaustively described by merely making reference to thinghood, end quote. Kirky recognizes the possibility of property status being crowded out by increasing legal protection, which may lead to a reclassification of animals in non-property terms. So the more than commodity term, I feel, aligns more strongly with the strategic direction of my thesis. And while my approach does accept the ethical necessity of working with a traditional property legal status as an inroad to change in the direction of abolition, to use more Francione phrasing, it does not view this acceptance as a resting place, and nor does it perceive mere amendment to property law categories as an optimal long-term strategy to improve the lives of animals that are currently categorized as such. Okay, that's Favor and Kirky. What about Fernandez and Kirky? So, in defining quasi property, Fernandez writes that given the changes we have seen in how non human animals are viewed, it becomes less and less plausible for the law to label all non human animals as property to court, and for that to be the end of the discussion. Quasi better captures the flux. End quote. She argues that, quote, quasi property, quasi person is a good temporary heuristic to help us organize our rapidly changing ideas about how to structure human relationships with non-human animals. Okay, so quasi-property appears then as a term that not only attempts to grapple the constantly evolving nature of animal status, but one which likewise intends to reject the traditional binary thinking in regards to this legal status. So Fernandez encapsulates the rejection of binary thinking by writing that living property or quasi-property, and she references Favor's work in this quote, both of those terms push in her idea non-human animals closer to being the kind of entity that deserves legal standing and a representative to defend their interests. So in my interpretation, more than commodity shares strong parallels with quasi-property in these regards. First, it serves a similar function as a heuristic, signifying an expanded space for the status of animals, which allows for the recognition of ongoing status expansion, especially in legal terms. Second, it acknowledges that recognizing non-property characterizations of animals may be employed by more CAS type theorists or critical animal studies theorists and actors to decenter the property elements of the status. And third, both appear to reject common historical binary separations, which I love, such as between welfare and rights and property and person, and consequently captures a wider spectrum of statuses between extreme endpoints as they're usually legally classified. So Kirky actually acknowledges this quasi-property in his A Bird's Eye View article, but characterizes his work as, quote, a more overall alternative account of animals' legal position, end quote. So I find Kirky's unique substantive inventory in particular within that account, which portrays the blurred boundaries between persons and things, legally speaking, to be helpful in capturing the blurred boundaries of animal conceptualizations in the DSB decisions that I analyze. And it's especially helpful in allowing a better appreciation of more than commodity elements to crowd out the commodity status of animals in these spaces. So while the DSB articulations of animals in more than commodity terms doesn't actually formally alter their legal status per se, I argue that it may serve as stimulus to crowd out the commodity features of their formal legal status to the point where their legal characterization as commodity or property is just no longer appropriate and requires more formal change. Awesome. So that's a little bit of a deep dive into the comparative literature. Let's move to the next slide, onto my second objective. Some more literature, but different literature. So fun new start here. Okay. A second objective of my whole thesis is to analyze the leading animal DSB cases. And there has been a select few authors that have considered in depth the treatment of animals within the WTO regime, generally speaking. And some have also considered more in depth the DSB cases that I also referred to. So notably Katie Sykes, Robert Housey, Charlotte Blattner, Thomas Couch, Ian Offer, and Radhiki Chowdhury. So my analyses aim to extract the most significant considerations of animals in the DSB and builds upon some of the relevant work conducted in this area, distinguished in certain ways. For example, in Protecting Animals Within and Across Borders, Blattner discusses one of the significant considerations of animals in the DSB, the portrayal of animal value in the case of US tuna to Mexico, as, quote, as exchangeable in terms of their survival, end quote, insofar as, quote, it does not matter that one turtle dies if they are replaced by another of their species to maintain the overall number of turtles necessary for conserving their species, end quote. So my legal work in chapters 5 to 7 shows the shift not only from the status quo of dealing with animals as products, but additionally from identifications of animal value as a function of environmental protection rather than as individual lives with moral status. My work demonstrates where the DSB has considered animals in not just more than commodity terms, but in terms that they are capable of suffering adverse impacts beyond mortality. That meaning as a metric for assessing environmental harm rather than harm to the individual. And that's kind of terminology that comes from the cases, adverse impacts beyond mortality, because the harms to the animals in some of the early cases very much are attached to harm to the species rather than the individual. Okay. So a further example is my agreement with Sykes and Housey's generally optimistic conclusions on the EC seal products case. For instance, Sykes writes in Animal Welfare and International Trade Law that, quote, welfare is a recognized and important justificatory, that's a fun word, the basis for legislation affecting trade. Quote, and Halsey writes in Globalization and Animal Law that the animal protection law at the heart of EC seals hopefully pretends a brighter future of WTO jurisprudence on animal protection issues. I somewhat qualify this agreement with a clarification of why animal welfare measures are not now guaranteed to be accepted as as legitimately trade restrictive because of the seals case. And I further examine ways in which they can be in Chapter 7 in a more like specific way. Cool. Let's move to the next slide, please. Thank you so much. So, final objective. Objective 3, drafting a proposed model of how states may defend a highly trade restrictive measure. So in chapters 8 to 10, present chapters 8 to 10, I applied the results of my analyses to a model exercise on how a trade restrictive animal measure may be defended in a DSV case. The general subject of animal protection measures examined within the context of GATT Article 20A, and that is the public morals exception to trade restrictive measures, has been previously explored, notably by Chowdhury and Blattner. Blattner's Article 20A overview and analysis occupies approximately 7 pages in protecting animals in and across borders, and broadly concludes that, quote, there are no legal or conceptual grounds to prevent states from indirectly protecting animals abroad by invoking Article 20A GATT. It's just like a very exciting concept. Okay, so that's Blattner's treatment of Article 20A. Chowdhury's Article 20A examination occupies a greater portion of one of her articles, and she applies her analysis more to Australia's existing live export licensing system and standards that more widely live export licensing system and standards than to a more widely non-state specific ban, which is something I'm contemplating. So she spends less time examining the potential legitimacy of a live export ban or import bans. Accordingly, part of the purpose of my thesis is to more thoroughly demonstrate why the WTO is not an automatic barrier to such a strategy. Next slide, please. This is where it gets to the kind of technical WTO stuff, but just to show what I'm doing in these later chapters. Throughout chapters 8 and 10, I unpack how the current approach of the DSB to analysing measures aimed at protecting public morals may allow for highly restrictive trade measures to be deemed legitimately trade restrictive. And I integrate the outcomes of the analyses I conduct in previous chapters, which show an increasing recognition of animals in more than commodity terms within the DSB, as well as important points highlighted for conducting an Article 20 assessment specifically, so assessment that may not be related to animal topics per se. Further, I apply DSB cases beyond the 3 animal cases to supplement those findings, especially in relation to Article 20 procedure, which is still a work in progress, if I may say so myself. So I present the case study as follows. We've got step 1, country A imposes a farm to non-human animal welfare measure, which results in a restriction on the import and export of live animals, and also a second measure which imposes stronger national farmed animal welfare standards for the production of those animals. And that's it's technically necessary to have the domestic law imposed before moving to the import-export law. And I go into that. So step 2, country B is like, no, don't do that. That's against WTO law. And I go through why. Why is that against WTO law? And it gets all technical again. But they argue that imposing the measure was trade restrictive, basically, and it's not justified by any applicable exceptions. Step 3, the panel's like, yeah, That is trade restrictive because it's an export and import ban. That makes sense. It would be. All bans of such a nature would breach the GATT. So let's move to how we get around this point. Step four. The WTO panel considers whether country A's measure is provisionally justified under Article 20A. And this is the fun part. This is where I wanted to dedicate all of my word count, but I had to do some other stuff in my thesis because this is really fun legal work. Okay, we move to the design test. Is the measure designed to protect public morals, or is it at least not incapable of doing so? What does that mean? I get into that. And then we move to the necessity test. Is the measure necessary to protect public morals? What does that mean? We get into that. Okay, those are the two kind of preliminary steps, I guess, you have to pass, provisional justification, and then we go to does it comply with the Article 20 chapeau requirements? And this is where most of the measures that get entertained under Article 20 fail. Massive failure rate with the chapeau requirements because you're basically arguing, does this measure, is it arbitrarily or unjustifiably discriminative? And the panel or appellate body for nearly all cases to date has said yes, it's arbitrary and it's unjustifiable. But for instance, in ECC or products, the EU was like, okay, we'll just kind of make it a little bit less arbitrary. We'll make it a little bit less unjustifiable. And then the WTO was like, cool, cool, cool. Yeah, you can kind of still do the same thing, but thanks for changing some of those rules a little bit. So there's ways around it as we work through the procedure. That's where I spend a lot of my thesis in this case study. So by working through the steps of a DSB analysis of a model measure aimed at protecting farm non-human animal welfare, I ultimately seek to demonstrate how states may harness the DSB's present analytical and conceptual position on animals to create meaningful laws which prohibit some of the most harmful practices used at the expense of these lives, like live export. Overall, in comparison to considerations of the subject, the three main contributions of my thesis to the literature are first, it's one of the, these are the kind of technical selling points I have to make for my thesis, so bear with me. It's the first in-depth investigation of the three leading animal decisions of the DSB case using my unique Cascal approach with the view of advancing animal interests. Second, it's the first such analysis of how the language choices of the DSB specifically reveal a shifting description of animals in more than commodity terms, which allows for the advancement of those interests. And third, it's the first work to apply DSB analyses to the often neglected farmed animals. Often neglected, too often neglected, through a model legal exercise which demonstrates how an animal protection measure may be considered legitimately trade restrictive within the WTO regime. Awesome. We're moving to the end, guys. Thanks for keeping with me. Let's move on to the next slide, please. Very good. Yeah, now some more. This came from my confirmation. This slide. But look, yeah, cool. My thesis is relevant and important. It's for the following reasons. Broadly, this is a more broad point of relevance and importance. Surveys consistently demonstrate citizens' increasing concern in relation to animal interests, indicating the need for work, which examines how those lives can be better protected. Second, states are introducing laws which recognize the moral status of animals, which may implicate trade and be challenged within the WTO regime. So strategies demonstrating how those measures may actually be defended are required, from my perspective, to ensure the durability of those laws. Third, the WTO remains the leading regime underpinning global trade. There's questions on that, but look, we'll make that claim. And they play a significant role in shaping the parameters of this trade. So I posit that this regime is unavoidable in considering the tools that are needed to build effective global animal law, and relatedly, strategies that can effectively contribute to ending harmful global practices that use animals as tradable property and neglect their moral status. Next slide, I think, is just some of my sources. Look how many sources I have. No, that's not all my sources. There's some of my main sources. Just if you wanted my slides and you want to see who I'm referencing, go to the next slide. Thanks. That's my presentation. Thank you so much for your patience, and I look forward to the Q&A.